If it pleases the court, my name is Omwanza Ombati. I'm going to present the first part of or the comments about the scrutiny report, and the second part will be presented by my learned friend, Senator Hilary Sigei. My lords, it's important to first appreciate that the purpose of scrutiny is an exercise that is meant for the court to have an impression of how the exercise of the election was conducted. And that's what you said in 2013, Raila. And secondly, also it's important to note that part of the process of scrutiny is to audit the election and make sure that the numbers are backed up by the paper trail. In the request for scrutiny that was done by the petitioners, my Lord, Chief Justice and members of the Supreme Court, the request was targeted. You'll find that particularly in petition number 5, and also the affidavit of Arnold Oginga, paras 81 to 91. That is where the scrutiny was ordered, and when you retire to consider this matter, my lords, I request that you restrict them to their case. Now, in terms of the orders that was given by this court, you'd find that there are 7 orders. I'll deal with order number 1 to 4. The first one was with respect to an order that IEBC should provide the applicants with copies of the technology system and security policy. This was complied with, except that the applicants also wanted the names, specific names of the system administrators. My Lord, this would not be possible because then you would expose system administrators to danger. The second order is with respect to a supervision of the servers, to have access to the servers of the National Tallying Center, to demonstrate how Form 34C was dealt with. The forensic image of the 34C was granted, and all parties were also given time to interact with this server the whole day. Now, the third and more important, part of that order also was to see whether there was any deletion of any Form 34A at the server. You'll find that at page 21 of the registrar's report, there was no deletion. There is not a single deletion of a Form 34A from the server. And my Lord, Justice Lenola asked a question on how was it that JPEGs were converted from JPEG to a PDF. My Lord, that answer is found at the registrar's report at page 12, and it's important that we read this. It's a short page because a lot of issues have been raised about this. You'll see whereby it says that the Form 34A, you'll find this at page 12 of the registrar's report, that the Form 34A would be scanned by the KIMS kit into a PDF, which was then transmitted into the storage server. At the storage server, the form is processed by an application to check for compliance, to certify that the security features have been complied with, and the PDF has all the features that are supposed to be there. That goes also to page 13. This is important because, my Lord, there was a theory of the middleman that was being propagated by one of the petitioners, and in this scrutiny we could not find any middleman. In fact, there was a direct link from where the results were transmitted. So the transmission was from the KIMS kit. It would go to the National Tallying Center. One form would go to the National Tallying Center. The second form would go to the constituency tallying center, and the third form would go to the portal. And in this path, results path, there was no middleman. That was the smoking gun that was used by the petitioner, and my lord, unfortunately, there was no smoke, and there was nothing that would find that was found in that. It's important, my lord, to demonstrate to this court that in the scrutiny, there was first compliance by IEBC about, in terms of the orders of this court, order 1 to 7, as far as was practicable. And number 2 is that in the case theory that was presented to this court completely collapsed. We are all aware, and we saw it, that the petitioner brought a case that was packed in a truckload. However, when that was subjected to scrutiny, it collapsed like a house of cards. So, my lord, the scrutiny has demonstrated that this election was conducted in substantial compliance with the law. If there are variations, they are minor and they do not materially affect the result. And we submit that this court should validate the win of the first and second respondent in terms of Article 140 of the Constitution. I would conclude and say that from what we've heard, my lord, it's important probably to, for those of us who didn't go to the schools that my friend Ayatollah went to, if you read the book of Macbeth, the play of Macbeth, the second play, you'd see that there's a debate. There's a debate about the devil and conscience. I think in one of the last acts, about a servant who's known as Lancelot. And this servant has this big debate on what is it that, he has the devil that is pushing on him and also his conscience. And he concludes that he would rather go, in fact, I quoted this because it's very interesting. He says that my conscience is hanging by my neck, the neck of my heart, and in my conscience is a hard conscience. However, the devil gives me a more friendly counsel, but I choose to run from that friendly counsel. My lord, with those few remarks, I will request that my learned friend, Senator Hilary Sigei, can continue.